Good afternoon, and welcome to McGuire-Woods Securities Compliance and Disclosure Update. My name is Stephen Older. I'm a partner in our New York office, and I'll be the moderator for today's presentations. For those of you who are less familiar with McGuire-Woods, we're a full-service law firm with more than 1,000 lawyers in 23 worldwide offices. Our securities experience covers all aspects of securities laws impacting public and private companies, as well as executive compensation. Before we begin today's program, I would like to call your attention to the Q&A icon. It's in the lower left-hand corner of your screen. Please use this to submit questions you may have for our panelists at any time during the program. We will do our best to address your questions in the time allotted, but we're limited to an hour, so if we do not get to your question, we'll follow up with you via email. You'll also find a number of other resources along the bottom of your screen, which you may explore during the presentation, including the meeting materials folder where you can find a copy of today's presentation slides, as well as a link to the recent white paper authored by McGuire-Woods Securities Compliance and Data Privacy and Securities Attorneys on the SEC disclosure analysis in light of the recent Yahoo settlement. Without further ado, allow me to introduce our first speaker, David Rivard. David is an associate located in our Richmond office and focuses his practice on corporate governance, M&A, and securities matters. Today, David will discuss stock buybacks and Rule 10b-18 developments. So, David, you're up.
Great. Thanks, Stephen. There are a number of ways for a company to buy back shares of its common stock. It can buy shares on the open market. It can purchase shares in privately negotiated transactions, including privately negotiated block trades. It can launch a tender offer that complies with the requirements of the Exchange Act, or it can repurchase shares through an accelerated share repurchase program, which involves the purchase of shares under a forward contract entered into at the launch of the program. Today I'm going to focus on open market repurchases under Rule 10b-18. I will provide a refresher on the requirements and other key aspects of Rule 10b-18, and then discuss a recent rulemaking petition that asks the SEC to take steps to modernize one of the requirements of the rule. There are several reasons why a company may want to repurchase shares of its stock. It may view repurchases as a way to return money to shareholders in a tax-efficient manner, address dilution concerns, increase shareholder value, invest excess cash when other alternatives are unavailable or less attractive, or signal confidence to the market. Given the potential impact that repurchases, and in particular open market repurchases, can have on the price of a company's stock, there is a risk that companies that implement and use a repurchase program may expose themselves to liability under the Exchange Act's market manipulation rules. Rule 10b-18 addresses this risk by providing a safe harbor from liability for market manipulation when a company repurchases shares of its common stock in accordance with the manner, timing, price, and volume conditions of the rule. To qualify for the safe harbor, a company's repurchases must comply with all four conditions on a daily basis. Failure to meet any one of the four conditions on a given day will remove all of the company's repurchases for that day from the safe harbor. Rule 10b-18's manner of purchase condition requires that all purchases must be effected through only one broker or dealer on any single day. This condition is intended to prevent the appearance of widespread trading that could result if a company instead used several brokers or dealers to repurchase its stock. Although only one broker or dealer may be used on any single day, a different broker or dealer may be used for aftermarket trading, and different brokers or dealers may be used from one day to the next. This one broker or dealer a day requirement only applies to transactions solicited by or on behalf of the company. It does not apply to unsolicited transactions, such as when a shareholder approaches the company about purchasing some of the shareholder's shares. Whether or not a purchase is solicited depends on the individual facts and circumstances of each situation, and the SEC has indicated that the announcement of a repurchase program will not, by itself, lead to a conclusion that a subsequent purchase was solicited. Under the timing condition of Rule 10b-18, a company's purchase of its own stock cannot be the opening, regular way purchase of the trading day, or occur within 30 minutes of the close of trading, or if the company's stock has a public float of 150 million or more and an average daily trading volume of 1 million or more within 10 minutes of the close of trading. The purpose of excluding purchases from the safe harbor that come at the open and close of the trading day is to prevent a company from establishing the opening or closing price, which often serve as indicators of the direction of trading in the company's stock, the strength of demand for the company's stock, and the current value of the company's stock. A company can repurchase stock under 10b-18 after the close of the trading day, but before the final sale prices are reported if its purchase is not the opening transaction of the aftermarket session, the purchase is effected at a price that does not exceed the lower of the closing price in the stock's principal market, and any lower bids or sale prices reported by other markets after the close of the principal market, and all other conditions of 10b-18 are satisfied. Turning now to the purchase price condition, under this condition, the price paid by a company repurchasing its shares cannot be greater than the last independent bid price or the last independent transaction price, whichever is higher. The intent of this condition is to cause a company to repurchase its stock at a price set by independent market forces in order to prevent the company from artificially supporting its stock price through its own repurchases. The fourth 10b-18 condition, the volume condition, limits the amount of stock a company can repurchase on the open market in a single day. The purpose of this condition is to prevent the company from dominating the market and leading investors to conclude that the market is functioning as more of an independent pricing mechanism than it actually is. Under this condition, a company's repurchases on any given day will not qualify for the safe harbor if they exceed 25% of the average daily trading volume of the company's stock over the 4 weeks preceding the week in which the purchases are made. This 25% limit applies only to repurchases under 10b-18 and therefore does not include any repurchases made by the company in privately negotiated transactions. There's an important exception to this volume limit for block trades. A company may purchase through one block trade per calendar week that is not subject to the 25% limit, as long as no other 10b-18 repurchases occur on the same day as the block trade. Any block trade that complies with this requirement is not included when calculating the 4-week average daily trading volume of a company's stock. In evaluating whether a company has satisfied the manner, timing, price, and volume conditions of the rule, it is important to keep in mind that any purchases by affiliated purchasers are attributable to the company and must, together with the company's own purchases, satisfy the rule's 4 conditions, including the condition permitting the use of only one broker or dealer per day. An affiliated purchaser under the rule is a person that is acting in concert with the company for the purpose of acquiring the company's stock, or an affiliate who controls the company's purchases or whose own purchases are controlled by the company or under common control with those of the company. Under the rule, officers and directors are not deemed to be affiliated purchasers solely because of their participation in the decision to authorize a repurchase program on behalf of the issuer. Generally speaking, a company's CEO and CFO would be considered affiliated purchasers, given their authority to direct the company's repurchase activities. Directors and other less senior officers, however, would generally not be considered affiliated purchasers unless they have a direct role in the program that goes beyond simply managing the logistics of day-to-day transactions, or they otherwise have a certain level of discretionary authority over the program. Rule 10b-18 is generally available for open market purchases of a company's common stock, but there are certain specific types of purchases of common stock that are excluded from the rule. In particular, once a merger or acquisition has been announced, the safe harbor is not available until the earlier of the closing of the transaction or the completion of the vote by the target shareholders, unless the consideration in the deal is cash and the purchase price is not subject to a valuation period, or in situations where the volume of repurchases on a given day does not exceed the lesser of 25% of the stock's 4-week average daily trading volume, and the company's average daily repurchases under 10b-18 during the 3 full calendar months preceding the transaction announcement, and any block purchases conducted do not exceed the average size and frequency of the company's block purchases during the 3 full calendar months preceding the transaction announcement. As I already mentioned, Rule 10b-18 safe harbor is limited to the market manipulation rules of the Exchange Act, which means that companies must be mindful of other securities considerations, and in particular any fraud considerations, including under Rule 10b-5. Generally speaking, a company should either avoid repurchasing shares when the company's trading window is closed or it is otherwise in possession of material non-public information, or should instead structure its repurchase program so that it complies with Rule 10b-5(1) safe harbor. For companies, there are 2 separate affirmative defenses available under 10b-5(1). The first is to comply with the requirements of 10b-5(1)(c)(2) by delegating purchasing authority to an individual who is not aware of material non-public information, and then adopting formal policies that either prevent transactions from occurring when material non-public information exists or prevent the individual with purchasing authority from becoming aware of material non-public information. The second option is to adopt a formal trading plan. As with any other 10b-5(1) trading plan, the plan must be in writing and entered into in good faith at a time when no material non-public information exists. The plan must specify the amount, price, and date of future purchases, or include a formula or other method for determining the same, and should not permit the company to exercise influence over how, when, or whether to repurchase shares. In addition to anti-fraud considerations, a company engaging in repurchases must also be mindful of Regulation M, which generally prohibits a company from repurchasing its stock at a time when the company is engaged in a distribution of the same class of stock. Stock buybacks, whether through open market purchases under Rule 10b-18 or some other method, have continued to increase in amount and as a percentage of earnings over the last several years. According to one study, the S&P 500 spent approximately 54% of earnings on stock buybacks from 2010 to 2012, while in 2016, approximately 66% of earnings were used for stock repurchases. In 2017, the S&P 500 spent approximately $530 billion on buybacks, and some analysts have predicted that that amount will increase to a record $800 billion in 2018, driven by tax savings and the repatriation of cash held overseas. As you might expect, many investors favor stock repurchases, and some are very active in pressuring companies to implement and use repurchase programs. However, there are a growing number of investors, analysts, and others that are concerned that such substantial buybacks are evidence of an unhealthy focus on short-term results. This concern has recently led to the submission of a few shareholder proposals that seek to exclude the impact of share repurchases from the performance metrics used to set executive compensation. If the amount of repurchases increases as much as anticipated this year, it will be interesting to see if a more significant number of these proposals are submitted. Turning now to the recent rulemaking petition. In March of 2018, Investors Exchange, LLC, a recently established national securities exchange focused on building fair markets, submitted a rulemaking petition to the SEC seeking a change in the price condition of Rule 10b-18. As I already discussed, under the price condition, the price paid by a company to repurchase its shares cannot be greater than the last independent bid price or the last independent transaction price, whichever is higher. The intent of this condition is to ensure that the price paid by the company is set by independent market forces. Ironically, according to the petition, changes in the market have created a situation where short-term, high-speed traders are able to identify company repurchases in the market and then make a profit by trading in front of those transactions. Essentially, traders are able to buy shares in the market at the company's offer price and then resell those same shares to the company at successively higher last sale prices. In order to address this situation, the petition proposes that Rule 10b-18 be revised to allow companies to repurchase shares at a midpoint price between the best bid price and best offer price. This change, according to the petition, would prevent a company's repurchases from being so easily identifiable and subject to manipulation, and would also preserve Rule 10b-18's objective of ensuring that shares are repurchased at prices that do not artificially inflate the price of the company's stock. In 2010, the SEC proposed amendments to Rule 10b-18 that raised the prospect of a midpoint exception to the rule's price condition, and there was, at the time, favorable reaction to the proposal. However, due to the priority of other issues, the SEC has not taken further action on the proposed amendments. Thanks, Stephen.
Thanks a lot, David. Our next presenter today is John Cornelius. John is also an associate in our Richmond office, and he concentrates his practice primarily on public and private offerings, corporate derivative and equity-linked capital market transactions, corporate governance matters, financial advisory services, and commercial business transactions. John will provide an update on recent developments in cryptocurrency regulation, as well as discussing initial margin regulations for uncleared swaps. John?
Thank you, Stephen, and thanks again to all of you who are joining us today. I'll start with the ever-changing world of cryptocurrency. This presentation is a follow-up to the discussion of cryptocurrencies and the blockchain technology that backs them up from our February webinar. I'm going to focus the discussion on how the primary regulators of cryptocurrencies, the CFTC and SEC, are trying to cope with the question of when a cryptocurrency is a security and when it is a, quote, pure cryptocurrency, or essentially a commodity. As you can see from the quotation on this slide from SEC Chair Clayton, at this point, at least publicly, the SEC is taking a hardline position on whether cryptocurrencies, also known as digital tokens, are securities. The next two slides provide some basic information regarding the two largest cryptocurrencies, Bitcoin and Ether. Bitcoin is the first and most popular current cryptocurrency with a market cap currently of approximately $140 billion. Bitcoin's development has several points that are key to understanding why the CFTC and SEC have largely decided it is not a security, but is instead a pure cryptocurrency. Bitcoin was released in 2009, but not by a company under the guise of initial coin offering, but instead it was mined by its creator, so-called Satoshi Nakamoto, whose true identity remains unknown. Bitcoin was then given or paid to people, some in exchange for their work on the Bitcoin blockchain. Bitcoin was designed as a pure medium of exchange, a form of payment that can be used across platforms and currencies. In December 2017, Bitcoin derivatives began to be offered on commodities markets like the Chicago Mercantile Exchange. The CFTC allowed these derivatives to be offered on each exchange after they self-certified that the product complied with the relevant Commodity Exchange Act and CFTC regulations. And note that the CFTC does dictate certain core principles that must be met and engages in heightened review of such self-certifications. Ether is the currency and what they call the fuel for the Ethereum blockchain, and it was first issued through an initial coin offering in 2014. The initial offering raised $18 million in Bitcoin, but it did not comply with Securities Act rules for public offerings. And the money raised was used to build out the Ethereum platform. It's currently the second largest cryptocurrency with a market cap of almost $70 billion. In recent months, the SEC has sought to halt new ICOs and others that were not compliant with the securities laws. As they've ramped up this enforcement, the established cryptocurrencies and the ICO market in general have become concerned about the status of the existing cryptocurrencies. As you can see from the quotation at the top, many in the digital assets community are really now just coming to terms with the fact that they are subject to SEC and CFTC oversight. In response, in March, an industry group met with the SEC to discuss a proposal that would effectively bless long-established cryptocurrencies that were distributed via an ICO. The proposal is that the SEC should consider decentralization in its determination as to whether a token is a security. Decentralization occurs when the token creator no longer has control of the network based upon its ability to make unilateral changes to the functionality of the tokens, when the token can be used for its intended purpose on the platform, and when basically the token is no longer useful as a speculative investment. The SEC was reported to be non-committal to the proposal. A similar argument has been pushed by others in the ICO marketplace based on their long-term understanding that if a digital token possesses a certain amount of what they refer to as utility, as in a value beyond just what they paid for the actual token, then its distributions would not constitute a sale of securities. One problem with this argument is at the time of the offering, most digital tokens have a questionable amount of utility. It's because they're often being used to fund the platform on which the token can later be used as a currency. Adding fuel to the controversy is former CFTC Chairman Gary Gensler, who made waves in April when he noted that the SEC will have to figure out how the hundreds of previously issued coin offerings and existing coin exchanges can come into compliance with securities laws. Taking aim at established cryptocurrencies, Gensler stated that there is a strong case that both Ether and Ripple, which is the third largest cryptocurrency with a market cap of approximately $30 to $40 billion, have been issued and traded in violation of the U.S. securities laws. Gensler's argument is based on the Howey test, that the Ether and Ripple tokens have the hallmarks of investment of money in a common enterprise with the expectation of profit. By contrast, Bitcoin is likely safe from SEC scrutiny because it was not issued in an ICO through a central organization and is considered a pure medium of exchange. However, the interesting part of this is today Ether is used almost exclusively as a currency and a fuel on Ethereum. Developers pay in Ether to have their apps hosted, to have people help build out their particular applications on the network. Essentially, the Ether exists externally from its creators, so in many ways it's become very similar to what Bitcoin was originally. The question is whether the SEC and CFTC will take the position that Ether, which was more than likely a security at its issuance, has somehow transformed into a commodity or a pure cryptocurrency, and is therefore no longer ripe for SEC enforcement. At this point, no one really knows the answer to that question, and the uncertainty is causing, as you can imagine, issues in the cryptocurrency markets. Another question is why Ether is suddenly under the spotlight. The short answer is that industry players want to list Ether derivatives and want regulatory certainty before commencing. Last week, CFTC Commissioner Quintens acknowledged that the SEC and CFTC are in discussions regarding jurisdiction on Ether. Given industry pressures, it is likely that the regulators will come to a resolution over the near term rather than long term. It is clear the status of the pre-existing cryptocurrencies issued by ICO need to be clarified, particularly for Ether and Ripple, the second and third largest. However, making its determination, the SEC and CFTC will likely look beyond whether Ether met the Howey test during its ICO, and take other factors into consideration, including what is the likely impact on the cryptocurrency and overall market going to be if the SEC imposes burdensome penalties on Ether and Ripple, which had its ICO in 2012. If the regulators decide that Ether is no longer a security and no real securities violations are currently occurring and kind of gives them a pass, on the other side is, does the SEC want to be seen as picking winners and losers? As I said, no one really knows the likely result, although just yesterday, Ether backers may have received a boost when CFTC Chairman Giancarlo, in a speech to state securities regulators, stated that the CFTC, quote, must be proactive in making regulatory and statutory framework that is ahead of the curve, prevents and punishes fraud and criminality, gives clarity and coherence to these emerging technologies, and anticipates the evolution of new instruments such as virtual currencies. Switching gears, the next topic is initial margin for uncleared swaps. These regulations have been in place for several years, but recently the CFTC Chairman Giancarlo proposed some interesting reforms. Initial margin is collateral, just the basics. It's collateral that is designed to secure potential future exposure in a swap. The CFTC published final rules relating to these initial margin back in December 2015, and compliance is being phased in yearly through 2020. Under CFTC regulation, initial margin is to be calculated on a daily basis using either a risk-based methodology, which can be created by the parties but needs to be determined based upon principles set forth by the CFTC and approved by them, or it can use a tabular method that's actually in the rule. Initial margin is collected daily as well, based upon the prior day's calculation. Initial margin rules apply based in large part on the entity's classification. Covered swap entities like swap dealers, financial entities with material swap exposure, and that means greater than $8 billion in gross notional exposure for uncleared swaps, financial entities without material swap exposure, and other counterparties like non-financial end users. Effectively, what this means is that the only time initial margin is not mandated is when a party is either a non-financial end user or is a financial end user without material swaps exposure. A couple of items to note. First, compliance is not only based on the classification, but also the average daily notional amount of swaps held by the parties. Second, if the party in the swap in question was not cleared because the parties used an exception from clearing, such as the end user exception, then it is exempt from margin rules as well. Here are the future compliance dates for the initial margin rules. As you can see, the next time it goes into effect is on September 1st of this year, and it will be exchanged if the parties have in excess of $1.5 trillion in average daily notional amount of covered swaps. I just would remind everyone that these, again, does not apply to a non-financial end user. With that background, late last month, CFTC Chairman Giancarlo and Chief Economist Tuckman produced a white paper in which, among many other important reforms, they argued for a reassessment of initial margin for uncleared swaps, based on the idea that the existing law is not consistent with the purposes of the Dodd-Frank Act. They noted that Dodd-Frank's derivatives requirements are intended to benefit society at large by reducing systemic risk, particularly by regulating the derivatives activities of large financial intermediaries. The failures of these entities, which move significant amounts of cash and credit through the financial system, are likely to spread economic disruption and start a cascade of bankruptcies. By contrast, commercial end users, even large ones, are unlikely to be sources of this systemic risk, so the criteria designed to protect against such risk should not apply to them. One proposal they had was that the notional amount, as currently calculated, is an inadequate measure of derivatives positions because it adds together offset long and short positions, which means risk-reducing trades could, in theory, put an entity over the threshold. They suggest an alternative method. It's called entity-netted notionals, ENNs, which net long and shorts within pairs of legal counterparties, within product classes, and within currencies, but not across those categories. The results can be dramatic. At a recent congressional hearing, Chairman Giancarlo explained that using ENNs instead of the existing methodology would reduce the current size of the interest rate swaps market from $179 trillion to just $15 trillion. The question is now, will the reforms happen? The paper didn't give a timetable, and while Giancarlo has indicated that he's ready to get started, even the paper admits that it would be challenging for the CFTC to implement many of the changes on its own. For example, even though the CFTC believes that the initial margin changes discussed before are consistent with Dodd-Frank, they're not consistent with the rules of other domestic regulators or international standards or guidance. As a result, it is likely the proposed reforms will occur on a longer timeline, if at all. That shouldn't diminish the reforms presented, many of which would make the rules easier and less costly for smaller financial companies and commercial end users. Thank you. Back to you, Stephen.
Thanks, John. Next up, we have Kurt Lenz, who's an associate in the commercial litigation group in our Atlanta office, with an emphasis on securities litigation and regulatory and enforcement matters. Kurt's going to review the SEC's long-awaited proposed rules and regulations on the standard of care that brokers and broker-dealers and investment advisors owe to their customers. So, Kurt?
Thank you, Steve.
Yep.
hope to provide a high-level summary of what the SEC recently did last month regarding the standards of care applicable to broker-dealers and interpreting the standard of care that investment advisors owe their clients. The SEC's proposal followed closely on the heels of the Fifth Circuit vacating the Department of Labor's fiduciary rule, which would have imposed a uniform fiduciary standard on broker-dealers and investment advisors for retirement retail products. The SEC's proposal, that, in light of some of the press and news and consternation that was caused by the Department of Labor's fiduciary rule, the SEC's proposal and SEC's own conduct flew a little bit under the radar, but is now at the forefront. So those proposals were released April 18, 2018. They were really a long time coming, even though I just said they flew under the radar. The SEC noted in its proposal, which spans 1,000 pages, it's pretty robust, but they noted that they had been considering issues of conflict of interest since as early as 1995 and had routinely included them in their annual examination priorities. And they also noted that commentators have for a long time called for a higher standard of care for broker-dealers. And we'll talk in a moment about what that traditional and current standard of care for broker-dealers is. Procedurally, the SEC is accepting comments through August 7th, 2018 on these proposals and has already received a number of comments. And we expect it to continue to receive comments, but not only are they receiving comments, but they're meeting with representatives from various companies. We've listed some of those there. And this is, the proposal in part is an outgrowth of Section 913 of the Dodd-Frank Act of 2010, which required the SEC to conduct a study on the obligations of broker-dealers and investment advisors. The SEC issued its responsive study in 2011, and one of the primary recommendations there was a uniform fiduciary standard of conduct for broker-dealers and investment advisors when providing personalized investment advice. What we see in the proposal ends up being a little bit different than that, and on the way to the proposal, the SEC called for public comment several other times in 2013 and 2017. And in a lot of ways, this new proposal is an outgrowth of the blurring of lines between the traditional services offered by broker-dealers and investment advisors and the resulting confusion to investors in understanding the differences in services provided by investment advisors and broker-dealers. Traditionally, investment advisors are paid to give investment advice for a fee, and they owe customers a fiduciary duty, whereas broker-dealers, at least in non-discretionary accounts, offer a wide variety of investments and products and services, but do not charge for investment advice. So the SEC's proposal does three things. And it's really a tripartite proposal in three different publications. The first is it establishes a new standard of care for broker-dealers, moving away from a suitability standard to a best interest standard. The second thing that it does, or the second part of it, is to interpret rules applicable to investment advisors. Specifically, it's addressing sort of the idea of the fiduciary obligation owed by investment advisors that's grown up in the common law in statutes. And then finally, it provides and it requires, or it would require, broker-dealers and investment advisors to provide written summaries of their roles to investors, and then related to that, it would limit what broker-dealers are allowed to call themselves. In several places throughout the proposal, the SEC states its belief that the roles played by broker-dealers, investment advisors, and those that are dual registrants are important and should be preserved, and that is one of the things that the proposal seeks to do. The other thing that the proposal seeks to do, though, is to provide transparency to investors, so investors understand what their investment professionals are doing and the scope of those services, the fees associated with those services. And if I were to boil down the proposals made by the SEC related to the standard of care for broker-dealers and the disclosure requirements that came out on April 18th, I would do it in 2 bullets, and it would be, 1, there's going to be a new standard of care for broker-dealers that is a heightened standard of care than the suitability standard, and the second one is that it's going to require increased dissemination of information to investors regarding the difference between the roles that broker-dealers and investment advisors play. There's the interpretation of investment advisors' role, and we'll talk about that a little bit, but it's really, when the SEC was talking about the investment advisors in that proposal, they were really talking about the laws that already existed and putting refining points on that law as opposed to plowing new ground, which is what they did with respect to broker-dealers. So with respect to broker-dealers, the proposal would create a new rule under the Exchange Act, which would require broker-dealers to act in the best interest of their clients, or to put the best interest of their clients before their own. The rule is creatively named Regulation Best Interest, and it triggers at the point of recommendation. So when a broker-dealer or their associated person is recommending an investment or investment strategy to their investor, they have to consider what is in the best interest of the client. This requires or excludes the broker-dealer or associated person from placing their own financial interest before that of their customers. Again, this new standard is the new standard would be a departure from the traditional standard of suitability. The current standard, and it's talked about at length in different places in the proposal, is the one that's provided by FINRA, which is the self-regulatory organization, or SRO, that governs broker-dealers. And FINRA rules state that a broker-dealer should have a reasonable basis to believe that a recommended transaction or investment strategy involving a security is suitable based on information obtained through reasonable diligence, such as the customer's age, other investments, financial situation and needs, investment objectives, investment experience, investment horizon, liquidity risk, risk tolerance, etc. That's basically the meat and potatoes of information provided historically to broker-dealers when opening accounts on new account forms or otherwise. That rule, the FINRA suitability rule, does not expressly preclude a broker-dealer from placing his own interest before his customers. For example, valuing commissions over investments best suited to a customer's needs. Nevertheless, some courts have found that broker-dealers should make recommendations that are consistent with their customers' best interests. Similarly, broker-dealers that exercise discretion in their customers' accounts may owe fiduciary duty similar to investment advisors under applicable state law. And that is the phenomenon that occurs in case law, where a broker-dealer has provided has discretion in an account, has provided investment advice, and you never know how they're going to turn out when you see them in the case law. It's very much a facts and circumstances situation where courts will say that a fiduciary duty has sprung into existence based on the relationship. One of the focal points of the rulemaking is to avoid conflicts of interest that broker-dealers face when making recommendations. And the new proposed standard, is summarily stated by the SEC, is that a broker-dealer or associated person satisfies its obligation of acting in the best interest of the customer if the broker-dealer or associated person of a broker-dealer, before or at the time of such recommendation, reasonably discloses to the retail customer in writing the material facts relating to the scope and terms of the relationship and all material conflicts of interest associated with the recommendation. The broker-dealer or a natural person who is an associated person of a broker-dealer in making the recommendation exercises reasonable diligence, care, skill, and prudence. The broker-dealer establishes, maintains, and enforces written policies and procedures reasonably designed to identify and at a minimum disclose or eliminate all material conflicts of interest that are associated with such recommendations. And the broker-dealer establishes, maintains, and enforces written policies and procedures reasonably designed to identify and disclose and mitigate or eliminate material conflicts of interest arising from financial incentives associated with such recommendations. So that is that is a mouthful. The SEC outlines what broker-dealers will be required to do under Regulation Best Interest to comply, and they placed certain obligations on broker-dealers and their associated persons. It basically creates three obligations, which they call, again, rather creatively, the conflict of interest obligation, the disclosure obligation, and the care obligation. So broker-dealers have to, under the Regulation Best Interest, establish written policies and procedures to identify and disclose or eliminate material conflicts of interest associated with recommendations and to mitigate material conflicts of interest arising from financial incentives associated with recommendations. These are the conflict of interest obligations. Currently, broker-dealers do not have an obligation to mitigate or eliminate conflicts of interest, and under the new regime, they will have to evaluate conflicts of interest to determine which have to be mitigated or eliminated and which can be addressed through disclosure. Associated persons would have to do the following before making any recommendations to investors. The disclosure obligation would require them to disclose the material facts relating to the scope and terms of the relationship, and this will work in tandem with the new form CRS that we'll talk about in a minute, and they would have to exercise reasonable diligence, care, skill, and prudence to understand the risks and rewards of any recommendations and have a reasonable basis to believe the recommendation is in the customer's best interest. This is not completely unlike the current FINRA standard. The difference is the addition of the customer's best interest being taken into account when making that recommendation. Importantly, CNTR is not required to establish a violation of Regulation Best Interest, and broker-dealers cannot satisfy their care obligation simply through disclosure. So, talked about it a bit earlier, what the SEC hopes to accomplish through Regulation Best Interest. Its stated goal is to enhance quality and transparency, and the SEC believes that the Regulation Best Interest does in several ways. One, by educating investors about the nature and relationship of their relationship with their investment professional, and that is something that the SEC has studied and written about in this proposal about how investors are confused by the varying roles that are out there, not knowing the difference between a broker-dealer, investment advisor, and that's further complicated by the fact that even within a broker-dealer, you have registered representatives that call themselves financial advisors, which would suggest that maybe they're an investment advisor and that person owes a fiduciary duty. And so that's one of the key components of what Regulation Best Interest does, again, with keeping these different options available for consumers and customers of using either a broker-dealer or investment advisor. The standard of care for broker-dealers that's recommended in the proposal is not universally liked. For one, it's sort of a midway point between the suitability standard that we currently have and what the Department of Labor done in the fiduciary rule, where it proposed a uniform standard. Kara Stein gave a particularly blistering review of the standard, likening it to the emperor's new clothes, basically suggesting that there's nothing there, and what we've really done is to continue forward the suitability standard. She also pointed out the omission of any definition of the term best interest within the 1,000 pages or so of the proposal. The proposal tackles that head on, though, the lack of a definition of a best interest, acknowledging it and saying that it avoided defining best interest because of the SEC's preliminary belief that whether a broker-dealer acts in the best interest of a customer is a factual determination that will turn on the circumstances of each individual recommendation. Turning to the investment advisor rules, the investment advisors have always owed a fiduciary duty to their customers. The SEC really just wanted to put a finer point on the duty of care and duty of loyalty that investors are owed by their investment advisors. Just running through quickly what the SEC clarified the duty of care requires investment advisors to provide advice in the customer's best interest, seek best execution by minimizing the cost of the transaction, and providing ongoing advice and monitoring during the course of the relationship. The SEC did note that this should be done on a portfolio basis, not a transaction-by-transaction basis, and also noted that this does not require investment advisors to recommend the cheapest investment strategy. Investment might be more expensive, but it might also still be in the customer's best interest, and an investment advisor might still serve its fiduciary duty by recommending that or providing advice for that investment. On the duty of loyalty, the SEC pointed out, clarified that it requires, and none of this is groundbreaking, which is why I said earlier my 2 points were there's a new standard of care for broker-dealers and there's some requirements around disclosure. But investment advisor has to put the customer's interest first. That is that's black letter law on fiduciary law. They have to make full disclosures of the advisory relationship, and they have to avoid conflicts of interest. So nothing groundbreaking there. The disclosure form will be new. One of the things that they require, and this ties it all together, and it ties in the transparency piece of what the SEC is trying to address, is that the SEC proposes that broker-dealers and investment advisors are required to provide a 4-page disclosure form that would describe the relationship between the broker-dealer and the investment advisors and their client. This would be called Form CRS, which is short for Form Client Relationship Summary. Key disclosures of that form include, and there's 8 of them, but the ones that I think are key that I wanted to pull out were, again, description of the relationship of the services provided, description of the standard of care. So for investment advisors, they'd have to say it's fiduciary care. Broker-dealers, they'd have to say best interest. Description of the fees and costs, and description of the difference between brokerage and advisory services. And then again, description of conflicts of interest. So that ties in all of the 3 obligations: the disclosure obligation, the conflict of interest obligation, and the care obligation that we discussed earlier in regulation best interest. Finally, and related to that, and related to the investment confusion that exists in the market, the SEC proposed limitations on the use of the term advisor by broker-dealers to avoid confusion. There's some finer points on that when the broker-dealers are allowed to call themselves advisors, if they're a dual registrant, if they're dealing with banks. But generally, broker-dealers will no longer be able to call themselves advisors or their associated persons advisors. So gone might be the days of registered representatives widely referring to themselves as financial advisors. Thank you, Steve.
Great, Kurt. Next up is our last speaker of the day, Lisa Taylor, who's a partner in our Jacksonville office. And Lisa advises on public company reporting and corporate governance matters with extensive experience representing publicly traded transportation and logistics companies. Lisa's going to review the new Proxy and Schedules 14A C&DIs that were released on May 11th of this year, so very recently. Lisa?
Thanks, Stephen. As Stephen noted, on May 11th, the SEC's Division of Corporation Finance issued a consolidated set of interpretations of the proxy rules in Schedules 14A and 14C. There are 44 questions and answers that replace interpretations published in the proxy rules in Schedule 14A manual of publicly available telephone interpretations and the March 1999 supplement to that manual. The SEC identified 6 of the questions and answers as reflecting substantive changes and 4 questions and answers reflecting technical changes. In this presentation, the full Q&A is restated for those questions identified as addressing substantive changes, and also briefly covers those that have technical changes and some other noteworthy interpretations. Question 12401 basically says that a soliciting party can exercise discretion to accumulate votes among director nominees by indicating how the proxy holder will vote if no choice is specified in boldface type on the proxy card, as long as state law grants the proxy holder authority to exercise discretion to accumulate votes and does not require separate voting, separate security holder approval with respect to cumulative voting. But this rule will probably be pretty minimal since so few public companies have cumulative voting. Question 12407 basically says that a registrant must file a preliminary proxy when it receives adequate notice in advance of a non-Rule 14a matter. Rule 14a 4c states that a registrant cannot exercise discretionary voting authority on a particular proposal if the proponent of that proposal takes 3 steps. First, the proponent must provide a timely statement that it intends to deliver a proxy statement in a form of proxy to that percentage of holders of the company's voting shares required under applicable law to carry the proposal. Second, they have to include that same statement in their proxy materials. And third, after soliciting that percentage of holders, they have to provide a statement from the solicitor that the necessary steps have been taken to deliver a proxy statement in form of proxy. This means that if the proponent of a non-Rule 14a proposal jumps through those 3 hoops by the deadline, which we'll discuss later, then the company will have to file a preliminary proxy and need to account for that extra time, at least 10 calendar days in its annual meeting and proxy soliciting timeline. In question 12602, the SEC clarified that a registrant is not required to file a preliminary proxy statement in connection with a proposed corporate name change to be submitted for security holder approval at the annual meeting. In its answer, the SEC explained that the rules relieving companies from having to file a preliminary proxy are intended to avoid unnecessary administrative burdens, and processing costs for matters that aren't usually selected for SEC staff review, and so a name change does not require filing of a preliminary proxy statement. Question 151 basically explains that a public company does not have to include Regulation SK Item 11, 13, and 14 financial disclosures in a proxy statement to authorize additional common stock for issuance in a public offering where the company has alternative means to fully pay for a recently announced acquisition, such as available credit under an executed credit agreement in the full amount of the acquisition consideration, and may choose to use those alternative means even though the registrant could use the cash proceeds from the offering of the shares to pay for the acquisition. Here, the SEC's answer in the CD&I provides noteworthy additional language and direction. They say raising proceeds through a sale of common stock is not an integral part of the acquisition transaction because at that time of the acquisition consideration is payable. The registrant has other means of fully financing the acquisition. The proposal would therefore not involve the acquisition and the Note A would not apply. By contrast, if the cash proceeds from the public offering are expected to be used to pay any material portion of the consideration for the acquisition, then Note A would apply, and the company would need to include all the Reg SK Item 11, 13, and 14 information, such as the MD&A, pro forma financials, and the like. Question 16103 clarifies in the new plan benefits table under Item 10 that the registrant should list in the table all individuals and groups for which awards and benefits information is required, even if the amount is 0, or alternatively, if the amount is 0 for any person or group, it could be recorded in the narrative discussion below the table. Question 16301 says that a proxy statement seeking security holder approval for the elimination of preemptive rights from a security would require financial and other information in the proxy statement to the extent required by Item 13 of Schedule 14A. So if a company would have to include all the Item 13 financial information like the MD&A, financial statements, qualitative and quantitative market risk disclosures, then seeking shareholder approval to eliminate a security's preemptive rights. Technical changes were addressed in about 4 questions. Question 12604 confirms that a Form S-4 filer must wait to send the proxy card until after the S-4 is declared effective. Question 12605 confirms that any additional communication to security holders after an S-4 is declared effective should be filed as additional soliciting material under Rule 14a-6b. Question 15801 confirms that items 7 and 8, information about an incumbent director who were recently elected at annual meeting, must nevertheless be disclosed in a proxy statement for a special meeting to elect one person as a new director. Question 15803 confirms that items 7 and 8, information about directors of a target company, must be included in the acquiring company's Form S-4 that includes the target's proxy statement. The interpretations include other helpful guidance. There are several interpretations about how to determine if a proponent's notice of a non-Rule 14a8 matter is timely. For instance, question 12405 clarifies that if a registrant has an advance notice bylaw that establishes a different deadline for receiving a non-Rule 14a8 matter, that deadline would apply rather than the 45-day deadline in Rule 14a 4c1. Question 12603 clarifies how to calculate the 10-day period between a preliminary proxy and the definitive proxy statement. The date of filing is day 1, so for instance, if the preliminary proxy was filed on January 6th, the 10 days would end on January 15th. So the company could send its definitive proxy material starting at a minute after midnight on January 16th. There are 12 question and answers in Section 161 of the interpretations addressing disclosures under Item 10 of Schedule 14A. So if a company is submitting a proposal about compensation plans for shareholder approval, you'll want to review those interpretations. The interpretations also address which types of transactions or proposals include Item 13 information in the proxy statement. So, for instance, question 16401 clarifies that financial statements don't need to be included in a proxy statement to increase authorized common shares and eliminate an unauthorized but unissued class of preferred stock unless the authorization is being sought in connection with a merger, acquisition, or similar transaction. Similarly, in question 16403, that clarifies that financial statements don't need to be included in a proxy statement for a merger intended solely to change a company's domicile from one state to another. So there you have it, a quick summary of these interpretations. Having these interpretations of the proxy rules in Schedules 14A and 14C in one place with recently updated guidance should help practitioners and the companies they represent. Back to you, Stephen.
Thanks, Lisa, and thanks to all our panelists for some great presentations. We're running sort of to the end of the timeline, so we're not going to be able to address the questions that we got during the call, but we will follow up with you via email from any of your questions you had during the presentations. Just a note, we'll be taking a hiatus for the summer months, but please join us again when we are back on September 27th. And again, on behalf of McGuire Woods, thank you all for joining us today, and have a great summer. Thanks a lot.